don't mind, I'm going to stand up. With a bit of luck, we'll see my slides in a minute.
Good.
I should say that we coordinated beforehand to try and get a certain minimum number of points in, which is why I've already got prepared comments. If you go to the next slide, please.
Well, I've got it here. Do you want to control it? Or?
Okay. So, from a lawyer's point of view, what I was asked to consider here is what is the role of economics in merger remedies? And I think, first of all, I should set the scene by saying what may happen. You have remedies coming in at various stages. I call it phase 0, which is pre-notification, phase 1 or phase 2. If you're in phase 0, in other words, you haven't even, the authority hasn't really had time to look at the case.
It's not enough.
It's not enough, okay. Can you hear me? Is that all right? You may get the reaction, well, we're not going to look at it yet. Let's park that and see. You put a remedy proposal forward. You are sometimes encouraged to put them forward, but there's a very practical reason why they won't look at it. For example, if you want to look at third-party information and do a bit of econometrics and you need data, you need it from third parties and it's difficult to get it before you've filed and got going. Then you go into phase 1. And remedies are clear-cut and broad brush, as we call it, dealing with whether there is a serious doubt about the merger. And that continues until, in phase 2, until there is a statement of objections offered. So in fact, you have longer than you think. You don't just have the 4 weeks with the extensions. You actually have a little bit of time in phase 2 to settle before you actually get into the whole locomotive proceedings of a statement of objections. And then you get the second phase's assessment with more precise focus on the issues. Now, it's the second half of this slide which really answers the question. In other words, we're asked, what is the role of economics in merger remedies? Well, to me, the first thing is asking the right questions, economists helping you to ask the right questions, and then in some cases you do quantitative assessment. Often it's disproportionate and unnecessary, so you shouldn't go for it. But right questions, always. And if an economist can help you to see the light and actually see how things, what is the right way of looking at it, this is very welcome. For the notifying parties, you're looking at economics all the way through. You'll do it in the filing, the whole case, and in particular when you come to the remedy proposal, because you have to justify it as giving you a viable business, a suitable business, a proportionate solution to the perceived issue. Then, if you are coming from outside, if you're a third party and you're contesting the case, you may bring in economics in order to say, but Commission, you got it wrong. You've misunderstood the proposed purchaser. He's actually very weak. You don't want that. This is the wrong solution. And then if you are a purchaser of the relevant business, you may also go to an economist, because you may say, I want to justify myself as the person who's going to bring competition. I'm going to use the assets in a way you like to compete in the market. I'm the right guy with the right incentives. Could you go to slide? Can we have the next slide, please?
You pressed the green button.
Okay.
Give it to me.
That one? Okay. Okay, so my theme is that if you're planning remedies, you clearly have to have proper consideration of the economic effects as you evaluate what is the counterweight to the perceived economic issue, anti-competitive issue. You have, and this is something that people seem to find hard to grasp, especially businessmen, you have a relative repositioning of the businesses. There's going to be a merged entity and you're going to give up something. But then the value of the merged entity changes. You put that into the hands of a third party, and then the question is, what do they do with that? Will they use it in the same way? Will they do it differently? What are their incentives to do that? How competitive will the structure be? So obviously that is all something which economics can help with. But economics is not all. And that's obviously a typical lawyer's statement here. Practically, I was involved in a case called, a merger case involving petrol stations. And it's called the Statoil Hydro and the Jet petrol stations in Scandinavia. And the interesting debate that came out was the choice of remedies. In other words, you could put forward a very tight competitive network, which was the most ultimately efficient network, or you could put forward a network which is slightly bigger but less efficient. What was the better compensatory value to the merged entity? And there was scope for judgment of the Commission, there was scope for consideration as to what they wanted, and you don't necessarily, it's not necessarily a hard and fast answer X in these situations. And I think you would get other examples. We were hearing a little bit about branches this morning. I think there was a reference to Waterstones and things like that. How many cases do you have where you have a centralized economic effect and then a localized economic effect, and you're balancing the two at the same level? You could be talking about Lloyds Bank and these branches. You can be talking about supermarkets. You can be talking about any of these industries. And you will have to juxtapose the two and think it through. 1 minute? Now, so I strongly believe that although remedies are based on everybody trying to get it right, both from the legal perspective and the economic perspective, the regulatory perspective, that it is in many cases l'art du possible, where you try to fashion what you think is a reasonable prediction and a reasonable solution for the context. And above all, I'm afraid it's the way in which we can understand the business best that really matters. It's the business, what I call business savvy considerations. What are the inputs that you really need to make this business work? Is it Bruce is talking about, network effects. Is it the size of the business? What are the things you need to make it work? Now, the last point I would make, and I've already touched on it, to me the difficult part is trying to assess the incentives of the acquirer and its potential to use the assets effectively. Will it want to compete in the same way? Now, obviously, I regarded, you made a reference to some Cabral literature. I think that's, the idea that you're buying off the entrant, I think that's a bit exaggerated. It's not, but it's true that if you give him something, you may find that he first of all, he's got to buy it. And then there is the question of what he wants to do with it. Is he going to compete head-to-head against you afterwards? And I also picked up on Bruce's comment of, restoring market structure does not restore competition. It may do, but it may not be the same competition. In the meantime, the market will have moved on, and you get a number of different things going on, and you can't really predict what those are going to be. So you do your best. Anyway, I think I've made my points, and stop.
Can I have an immediate question for John? You talked about the role of economics and the importance of economics, but who actually performs the economic analysis in a case? Is it the economist?
Well, it's not me, I can tell you. In most cases, you will, from our point of view, it's what the client decides. You have many clients who have now very good economists inside the company, and they will dictate what is the economic philosophy, why are they doing the deal, they've done their homework, they don't need any help, they tell you what the answer is, and you help them to present that information. In more complex cases where you're going to the edge, where you're rolling the dice to see what you can get, you will be rather strange not to have taken economic consultants and to have worked out what are the likely ways in which you would have to present it, what's the data you need, done your homework, and done all of that. But I come back to my point about the right questions. I actually use solo economists, not big boutiques, and consult with them frequently in saying, well, have I got this right? Is there something basic we're missing here in the way we're presenting the case? and it's enormously valuable. You just get a little bit of insight you think you know. The business people are explaining it in a certain way. I think I've understood it. But actually, sometimes a business consultant is an economist playing the role of a business consultant, because that's what you do extremely well. That is often the most useful input, especially, and it's even on phase 1 cases. It's not on phase 2. You phase 1, if I fill in the form a certain way, then I've answered the questions of the regulator and I'm in good shape.
Thank you. Thank you, John. It's not the first time I've asked John this question.